Program and the Indian Institute of Corporate Affairs. This particular webinar has been organized in association with the World Bank. And I remember the last session we had with the team from World Bank was on World Bank insolvency regime ranking parameters. And Mahesh sir has been very kind enough to accept our invitation for this webinar as well. So thank you for that, sir. So just a brief introduction about Mahesh. He's the global manager for financial inclusion and infrastructure in finance, competitiveness, and innovation global practice at the World Bank Group. In his role, he manages WBG's global work on payment and market infrastructures and is responsible financial access insolvency. Mahesh sir is also the chair of the International Committee on Credit Reporting and oversees the World Bank's Insolvency and Creditor Rights Task Force. Prior to joining World Bank, he worked at the EBRD and as a commercial litigator at a leading Canadian law firm. Sir is also a board member of Insol International, and he has published and taught at the university level and lectured extensively in North America, Europe, and Asia. So at GIP, we have always endeavored to engage in discussions around the latest developments in the insolvency laws of not just India, but the other jurisdictions as well. And the insolvency regime is fairly new in India, and therefore these discussions help us to reflect and improve on our own laws as well. So the topic that we are going to deliberate on today is MSME and insolvency need for a special insolvency regime. As we are all aware that just a few days back, the government of India came out with an ordinance for the introduction of the pre-pack insolvency for MSMEs. So this discussion is going to be in line with that, although we are not going to talk about India specifically, but about MSME insolvency laws in general. So before we begin, there are certain house rules that I would like to clarify. First is that we would like this session to be as interactive as possible. So please feel free to type in your questions in the chat box that's been provided. And if it is not taken up immediately, it will definitely be taken up at the end. We would also be sending the questions to Mahesh sir separately if any question remains unanswered. So please put in your questions. And yeah, with that, we can begin. Over to you, Niti ma'am.
Thank you, Rustum. So I'm gonna keep it very brief, and only word that I have for you, Mr. Tupsindani, is thank you, because despite your busy schedule, you always make yourself available for Indian professionals, and especially the GIP students. So I think we will deliberate more on the questions that I have, but let us first take some opening remarks from you on insolvencies from SMEs. Over to you.
Thank you very much. So first of all, thank you for inviting me. It's always a pleasure to do this, and I'm always honored to be invited to speak to this kind of group in India. And I've been involved with the insolvency reforms in India going back now to 2005, 2006, when the Planning Commission in those days had invited Dr. Raghuram Rajan to chair the Committee on Financial Sector Reforms. And if you go back to what we wrote in the Rajan report, you'll see that many of those recommendations and reforms ultimately were embodied in the IBC. And so the IBC reform, I think, was, a very welcome reform. And what I've been particularly impressed to watch since then is how willing the government has been to revisit the IBC and continue to make tweaks, not least of which is the new pre-pack arrangements. So let me provide a little bit of context for what we're going to talk about today. And I agree with Dr. Niti that we would like to have as open a discussion as possible. Just very briefly, because of where we find ourselves in the middle of this COVID pandemic, our expectation is that globally 120 to 160 million people will be pushed into extreme poverty, right, as a result of this pandemic. And a big part of that is related to the loss of employment. And as we all know, SMEs or MSMEs, and I'll use those terms interchangeably, by the way, make up a significant portion of global firms, over 65%, and a significant proportion of global employment, close to 50%. And so the pandemic has really wreaked havoc on these kinds of firms, and has triggered, I think, quite a bit of loss of income for those workers, right? So we're in a time where providing support to viable SMEs, whether it's through financial support or through the legal and regulatory system, is even more important. We've also seen that, in particular, those SMEs owned and run by women have been particularly and disproportionately hard hit. Women's jobs are 1.8 times more vulnerable to this crisis than men's jobs, and women make up 40% of total employment, but about 54% of total job loss since this pandemic started, right? Now, we have seen globally about 113 countries have adopted 720 plus different measures to support SMEs. The majority of those measures are debt finance. Some of them relate to tax measures, employment support, and of course, legal and regulatory forbearance. Now, what that means is that a lot of SMEs during this pandemic that have continued to survive have done so by taking on additional debt. And that is a challenge that they are going to then face to deal with that debt as the years come. And so having a way to reorganize, restructure, resolve those debts is going to be ever more critical. So we did a series of so-called rapid surveys to gauge the challenges that SMEs were having during this pandemic, and try and really capture at the firm level what we're seeing. And what we're seeing is, number one, a large and persistent drop in sales, and that since between May and July of last year, for example, sales were reported by most SMEs to be 53% lower than in the previous year. And firms in countries with steeper drops in mobility have experienced sharper declines in revenues. Now, a lot of firms have been able to hold on to workers, but through reducing their wages and reducing their hours of work. So, of course, that impacts the workers. More than 55% of SMEs are already in arrears or expect to fall into severe debt in the coming 6 months. And as we all know, some sectors are more hard hit than others. Restaurants, hotels, that sort of thing, have done much more poorly than financial services, for example. We've also seen with these SMEs, because they are small, because they tend to be less formal, because they have less access to traditional bank financing, about a third of them have, only about a third of them have expanded to digital platforms, right? So it's been very difficult for these firms to migrate to fully online sales. I think India does better than most countries in that regard. India and China both do very well. But in general, it's been hard for these firms to migrate to fully online. So where there have been COVID-related lockdowns, for example, these businesses have been hard hit. And then, of course, uncertainty about the future is much higher amongst these firms. And so there's much more pessimism about their recovery prospects. So in developing economies, particularly, only about 10% of these firms report receiving any serious support from the government, compared to about 30% in larger economies. So, taking a further step back, what we do at the World Bank, we are in response to COVID, we're probably doubling our lending volume this year. We'll be lending about $160 billion across all of the countries that we work with. But we are also the designated standard setter, along with UNCITRAL, the UN Commission on International Trade Law, for insolvency. And several years ago, prior to this pandemic, we undertook the task of trying to understand what is it that MSMEs need in the insolvency space that's specific and unique. And we developed, as working with our task force, a set of standards for the design of SME insolvency systems. Those standards will be formally launched on April 25th, and I would encourage all of you to watch for them. They'll be published on our website. And on May 6th, we will be running a webinar available to all of you on SME insolvency. So I will share both of those pieces of information with Dr. Neeti, but I would encourage all of you to see that. And I would also encourage you, as I mentioned earlier, Dr. Raghuram Rajan, He opened our insolvency webinar series with us on March the 6th, March 6th, along with our president, David Malpass. And that recording is available for you to watch, and I would really encourage you to watch it. So I'll share all those details. But when we started looking at this issue a couple of years ago, we found that SMEs are a significant part of the global economy, right? Just as there are a large number of SMEs, there are a large number of SME insolvencies. However, there were very, very few specialized legal insolvency regimes around the world for SMEs. Most jurisdictions have treated and continue to treat SME insolvencies as the same as other corporate entities. And we know that, I think we all know that that's probably inadequate. So we set out to look at three things. Let's consider the specific challenges that insolvent SMEs face. Let's look at how different jurisdictions deal with that challenge. And then let's consider, as we have, where the international standards need amending. Now, in terms of the specific needs of SMEs, what we found is that complex insolvency systems tend to deter SMEs from resorting to formal procedures to tackle their financial distress. That was the first finding. Many countries use complex systems that unsophisticated SMEs struggle to understand, and this discourages the timely use of insolvency systems by SMEs. And remember that timeliness in insolvency is the most important thing. It is often the promoter herself or himself that is the first to know the business is in trouble, long before the creditors know. And encouraging these people to recognize those challenges and commence where it's relevant an insolvency proceeding is the most predictive element in whether that firm can be rescued or saved. So time is of the essence, right? And this complexity of insolvency systems tends to do harm to that early access. The other thing we found is that creditor behavior is a challenge. Where creditors have few incentives to deal with SME debtors through a legal process, those that are unsecured generally have limited participation in the process, and those that are secured typically just focus on the enforcement of their security at the first sign of financial distress. And you know, in India under SARFAESI, these creditors are given, quite sophisticated rights, and then some of the options and efficiencies of a restructuring could be lost because the incentives aren't there. The next challenge we found is the lack of information about SME debtors, right? SME debtors lack good records and reliable financial information. This makes it harder to assess the viability of an SME debtor, and it really does damage to creditor trust in the SME debtor and the effectiveness of the insolvency process. The next challenge we found was post-insolvency financing. Many insolvency systems don't permit or incentivize any kind of DIP financing or financing after formal insolvency proceedings are filed, even though this financing will be crucial to SME survival. And SMEs are specifically vulnerable to this risk, right, of being cash flow negative when they are restructuring and not being able to access additional capital. We also found SMEs tend to have insufficient assets to fund a formal insolvency procedure. They often lack the resources to cover the costs and fees of a formal procedure. Next, and I think these next two issues are really critical, SMEs are often financed with a mix of business debt and personal debt taken on by the promoter, including potentially personal guarantees being granted. The failure of an SME therefore has potentially severe consequences, not only for the promoter and for the shareholders, as it were, but for their family, including the social stigma that comes from that failure. Finally, natural persons. The SMEs might be informal entities that have not been incorporated, and such as sole proprietorships. In many jurisdictions, they're therefore subject to the same insolvency regime as natural persons, which might not have the necessary commercial controls to protect the financially distressed business of an SME. So we came up with, I think, 6 main conclusions. First of all, any definition of SME should not be overly narrow because the definition varies around the world. Second, any SME insolvency regime should address the particular issues that arise in the case of SME insolvency, but should sit within the existing insolvency framework broadly. Third, since the majority of SMEs are facing insolvency are more likely to liquidate, not to go into restructuring by virtue of their size, the framework should not only focus on reorganization and restructuring, but also on expediting liquidation and making it cheaper and faster and more transparent. Fourth, due to the lack of sophistication on the part of SMEs, jurisdictions should consider providing out-of-court assistance to SMEs, such as mediation, debt counseling, financial education, or the appointment of an IP, and providing potentially some funding assistance. And I want to come back to this point in a second about out-of-court. Fifth, further exploration is needed between the intersection of personal insolvency and SME insolvency. And finally, we concluded that standards are needed, and therefore we pressed on to develop those. Now, what have we found in those standards? These principles facilitate the rescue and restructuring of all viable SMEs with the objective of preserving entrepreneurial initiative and businesses that can continue to operate and add value in the economy, and to liquidate non-viable ones. They contemplate specific and key objectives and policies that countries should consider in the design and implementation of effective SME insolvency regimes, which are pursued by minimizing complexity and the costs of ordinary insolvency proceedings and creating favorable conditions for debt restructuring and discharge, preserving adequate safeguards for protecting the rights of creditors as well. Next, an effective SME insolvency regime should have the following main components: an out-of-court or informal mechanism, a hybrid mechanism like a pre-pack, and simplified procedures applicable to both natural and legal persons. A discharge regime for natural persons, and should be flexible and not offer detailed prescriptions. So, in turning now to the specifics of simplified SME insolvency regimes, let's look at eligibility. Each country dealing with this should clearly define the criteria to determine which debtors are eligible for access to simplified insolvency proceedings. Second, commencement criteria. Commencement criteria for SMEs, for SMEs should be simplified and should provide convenient and inexpensive and quick access to the restructuring regime. Three, procedural formalities. They should be characterized by fewer and simpler procedural formalities and shorter deadlines than those existing in ordinary insolvency proceedings. And this offers some protection to creditors as well. Fourth, management. We believe that managers should continue to administer the business in simplified organization proceedings. Fifth, management could be replaced by an independent insolvency representative. However, the law should state explicitly under which circumstances that may occur, and those should be exceptional. Six, dealing with reorganization plans. In simplified reorganization proceedings, requirements for creditor approval of reorganization plans should be less complex than in ordinary proceedings. Notwithstanding this, creditors and interested parties should receive timely and proper notice of a reorganization plan that could affect their rights. So those are the sort of key elements. Now let's turn to discharge. Discharge of a natural person entrepreneur is the primary feature of an SME insolvency regime. And a debt discharge for consumers is a related issue, but there clearly should be a discharge for the entrepreneur. Now, once the legal regime is resolved, I think institutional considerations also need to be considered. The role and function of institutions, whether it's the courts, the IPs, the other participants, should be modified according to the complexity, level, size, or other relevant features of the insolvency regime of a particular jurisdiction. So, look, I know I spent longer in that introduction than we had originally discussed, but I wanted to provide an overview, both of the background that motivates this discussion around SMEs, why I think it's particularly important now, and then what we think needs to go into those regimes. But maybe Dr. Niti, I can turn it back over to you.
Oh, thank you so much. That was a very detailed introduction, and it has really set the premise for the discussion today. So my first question is, you spoke about World Bank's endeavor to look at how it could support MESMEs. Now, as I understand that most of these help that comes to these MESMEs comes through state agencies. Now, as you know, a country like India, where not all the SMEs are registered with the government, you know, uh, not all these uh, SMEs who need help can get help, even if the World Bank is ready to provide help. So, do you think alongside the state agencies, there's also a requirement from the policymakers to set a different or a separate or an analogous platform where they could they could voice their concerns or they could access for different answers, etc. In other words, how can financial institutions who are not state agencies can participate in this?
So I'm not sure I fully understand the question. I think informality in general is a large and complex problem, and you're not going to solve it with the insolvency regime, right? It has tax implications. It has other implications. But so if the firm is informal, it's very difficult for it to receive any kind of assistance. And I don't know that a formal insolvency regime can respond to the needs of an informal business. I'm not convinced that it can.
No, that's a very, very valid point you made. In fact, that is one of the reasons why government has been encouraging all these MSMEs to get registered. Uh, but there has been a lot of talk also about, putting up insolvency framework for the individual insolvencies alongside for those for the MESMEs. Otherwise, one without the other would keep the whole objective, it will turn the whole objective futile. So, do you think there's some learning for India, or there's some, urgent need for India to focus alongside, the individual insolvencies, and how do you think we can bridge up
I
that gap?
absolutely do it. I absolutely do it. And that's why I was making reference in my remarks to discharge. I think to look at SMEs and forget about the promoter or the natural person behind it will only attack a very tiny part of the problem. And so I think whether you frame it as part of the SME insolvency system or you frame it as personal insolvency, ultimately you need to get to the same place, right? Which is you need a simplified process. Creditors need to be protected. There needs to be a recognition that there will have to be some forgiveness, for lack of a better word, of that debt through a discharge process. And then, of course, you have to guard against the moral hazard, right? There needs to be some exceptions and things that are not discharged. And certainly, of course, always fraudulent behavior is outside of that realm. But I absolutely agree with that.
Uh, Mr. Uttam Chandani, there's another question that comes to my mind is regarding the, one size fit all approach that most of the legislation adopts to. And I was going through one of the papers released by the World Bank, under your leadership, which talked about that for MESMEs, you cannot have a one size fit all approach. And where you talked about mediation as one of the options or a specialized framework. Now, whatever the case may be, how do you think a role of legislature could be sort of designed in a sense that how formal should be the mechanism for insolvency resolution for MSMEs? Do you think a formal legislative mechanism is what is warranted, or do you think we should keep it as light as possible?
I, I maybe it's a little controversial to say, but I don't think it matters in the sense that I think it matters what works, right? Now, it can be done through a formal legislative process. There's countries like Serbia, for example, have formally adopted legislation on informal workouts, right? Which sounds like a contradiction in terms. But in their legal framework, it works. In Iceland, for example, after the global financial crisis, Iceland adopted a voluntary debt restructuring scheme, which was basically targeting SMEs. And under that scheme, it created a framework for involuntary workouts where SMEs were to be reviewed and loans to viable SMEs would be written down to the net present value of their cash flows as estimated by the corresponding lender. So it was a system-wide scheme, right? that was designed to facilitate a kind of out-of-court restructuring, but it had a formal imprimatur of the government. And I think sometimes that's necessary because there are things, again, around insolvency, whether it's the tax rules or sometimes the labor rules, that need to be adjusted, right? So you might need that formality to incentivize those informal restructurings.
So you may be also aware recently India has introduced pre-pack for SMEs, and the recent ordinance that passed in India prescribed default limit of 10 lakh rupees to trigger the process of pre-pack insolvency for MSMEs. So basically, stress is quantified by assigning a particular value to it. Now, do you think an ideal MSME insolvency framework should also take in account a pre-default stress situation wherein debtor itself has an option to initiate if he feels it is difficult to continue the business profitably?
So I think the more you get to smaller and less formal businesses, the more sharply defined rules you need, right? So in the context of large corporates, we've come to a situation in many jurisdictions where, you know, we have cash flow tests for insolvency, we have preemptive insolvency, we have anticipatory insolvency. And I'm not saying that can't work for SMEs. I think the more complexity you load on to this to try and capture every situation, I think the more difficult it will become. And remember, right, at the end of this, I don't think the system has to be pro-creditor per se. I think that's a bit of a false, dichotomy between pro-creditor and pro-debtor. But the level of complexity should not be so great that the Sarface creditor wants to simply grab her assets or grab his assets, right? And so I'm not convinced. I'm sure it could work in the right circumstances, what you're describing. I'm not convinced it's necessary for what you're trying to capture as the majority of cases here.
Yeah, that's very insightful, sir. A related another question is, MESMEs have greater dependence on bank loans and therefore in general, they have a higher NPAs. Now, in what ways does having a separate insolvency framework for MESMEs have an impact on the lending behavior of financial institutions? Now, in your experience, do you see any drastic change in MESME lending after implementation of a targeted insolvency framework for them?
I think there's some empirical evidence. There have been some papers done in Colombia and elsewhere that have shown a drop in the cost of borrowing for SMEs. I think that will take a long time to materialize. I think that's the objective, right? Which is a lower cost of credit, greater accessibility to finance. But I think it's dependent on not only the legal regime working properly, but on the banks in this case, as you say, becoming sophisticated and familiar enough with the system and using it enough to be able to leverage it and see how it works to their advantage. That's the only way you reduce the risk premium and the cost of credit. You're muted, Nikki.
Yeah. So that's I think that's what we all are aiming to achieve. Lowering the cost of lending in future. Now, a follow-up question on that would be, there are a lot of issues with connected party sale, which is not just an issue in India, but also in the case of UK, where despite dispersed shareholding and I would say relatively better corporate governance, there has been a lot of issues with connected party sale. How do you think a developing or emerging economy should address that part? Or do you see
in
it
the
not as
SME in the SME context?
in the SME sector, sir?
So I think that's a difficult question. I think you can have a prohibition on connected party sale. I think that's probably the best way to go. Have an out-and-out prohibition on that, right? I think it's okay, just in the bigger context, to create a narrow path to restructuring for SMEs, right? I think it's, again, as I was saying, there's a recognition that the bulk of these SMEs will be liquidated, and efficient liquidation is an important factor in an insolvency regime, right? But for the ones that can be restructured, I think it is important to have maybe a fairly narrow path.
Yeah. Our friend Aurelio is also here, and a lot of corporate governance scholars argue that connected party sale, unless there's a fraud or there's a mala fide, is not a problem, and not always a connected party sale is a problem. And I think in India that'll be a greater challenge because most of these SMEs would or maybe a promote, a family-driven business, or I would say the level of informality and alongside the information asymmetry is really really high. So I'm not sure even if legislature tries to sort of curb that, how would that be? But I'm glad to hear that you do see that there should be some regulations around that, and I think Indian government also sort of taken note of that. My another question would be regarding role of IP. We just had a chat, a webinar with Professor Riz, and he was a view that role of insolvency practitioners in MESMEs should be only when it's needed. And what he was suggesting is sort of a framework, if I've got him rightly, that was suggesting that corporate debtor should be free to sort of really, raise the, red flags, and we should be free enough to, move ahead with restructuring or insolvency resolution. Now, how do you see, with your vast experience, global experience, how important is an insolvency professional's roles to be in MESME insolvency regime? Should it be like an oversight role, the way we have, India has proposed, or should it be like a more involved role in the managing the business, or any other hybrid model that you suggest, sir?
So I think there's two things. In general, I think it's more of an oversight role, right? Because again, you want to keep the costs low, and having the insolvency professional come in and run the SME. I mean, you imagine a typical not a typical, but you imagine an SME, a coffee shop, right? Having an insolvency professional come in to run the coffee shop is a little bit overkill, right? And may lead to sort of unworkable level of expense. At the same time, I can see a different type of resolution professional evolving, or a different subset of resolution professional, and I've seen this in other countries, where she becomes more of a debt counselor, right? And is helping the SME consolidate its debt, helping put together a restructuring plan. So much more from the perspective of the SME than of the creditors, but still as an officer of the court, if you like, with a duty, to behave ethically. But I don't see them coming in like you would have on a large corporate and running the business, and dealing with suppliers. And I think that's too expensive.
Yeah. Right. Another question is, it takes me back to the point where you spoke about how personal assets of promoters get so intertwined when it comes to insolvency of MESMEs. Uh, in this light, do you think it's necessary to provide some sort of protection, maybe in form of moratorium, to the personal assets of promoters till the time the distress of MESME is being resolved?
I wouldn't think so. I would think that you would want to provide the same kinds of, or similar kinds of exceptions that you provide in personal insolvency regimes. So some assets are simply excluded, right? But I wouldn't think that you necessarily need to provide blanket protection to all those assets. I'm not sure if that would be workable. And again, you'll see me repeating this over and over again. I come back to this idea that the complexity of the system has to be reduced. If it's too intricate, right, it will collapse under its own weight.
Right. Yeah, that's a very very good point that you mentioned, that the regime has to be simpler. Uh, Otherwise, the cost of enforcement, cost of compliance for MESMEs would go higher, and
yeah,
they'll not be able to take the benefit.
And I think you were talking about my perspective working. I've worked on insolvency across probably 100 countries, and I think one of the biggest dangers of an insolvency regime, frankly, is that it doesn't get used.
Right.
Right. It's very different from a tax code, which once you
Right.
pass the tax code, it impacts everybody, right? An insolvency
Right.
regime could be well designed and just not be used, right? And I think so. Some of these complexities we're talking about go into the utility of the regime.
Right. Um, my next question is regarding the management, dislodging the management in case of insolvency of MESMEs. Um, will it not, what do you think should be the approach, right approach? Uh, in case of MESMEs, and small creditors seem to be sort of disengaged from the process. And India has tried to address this issue by giving priority to the OCs. Now, if we take away the right from the creditors to appoint RPs, what is the incentive that remains with FCs in the process? Do you think we sort of have missed the clue here, or do you think it might work in our country?
I mean, look, the incentive is always the same, right? The incentive is I do better than I would in a liquidation, right?
Right.
So I don't think I think keeping management in place again, right, is the primary issue there is keeping costs low, right? And if we're talking about the kind of scale we're talking about in India of SMEs, I mean, the idea that for each of these that the creditors would assemble would displace management, I think is probably not practical.
Right, right. So, now going back to the case of India, where you have almost 6.3 crores MESMEs, one problem that most of the MESMEs are facing is about the sophistication of information that they hold, and most of the cases, informations are not well kept. Now, in that case, sir, what kind of regulatory infrastructure is needed to be developed by the state to withhold the creditors' trust in MESME insolvency? Because these MESMEs are too small to follow up, and everyday financial information needs to be either in a declaratory form or by the way of affidavit. So, what
Yeah.
kind of infrastructure we build in so that the creditors' trust nevertheless is instilled in the process?
So I think that's where the IP again could play a role, right? And that's what I meant before as, you have to think of the IPs not just as the big four accounting firms, but there would be definitely levels and layers, right? And this kind of IP would still bear that certification. So the creditors could still trust that he or she is behaving above board in an ethically way and provide a certification of the financial position of the debtor, of the assets and liabilities. And I think that could be done in a kind of administrative process. You can imagine a kind of tribunal type process where you have not even a judge, but a sort of tribunal. Tribunal is the wrong word. I mean, really like a much lower court kind of concept with the resolution professional doing that. And that's what I've seen work. That's what I've seen work in my home jurisdiction in Canada. That works very well.
Right, sir. We are open to questions from the audience, and I see Abhi has raised his hand. Abhi, would you like to speak into the mic? You can unmute yourself and speak into the mic. Yeah, you're not audible, Abhi. In case there's a technical issue, maybe you could just write down your question in the chat box.
Can you hear me now?
Yes, we can. Yeah.
So good afternoon to all first. And ma'am, as you pointed out that there are 6.3 crore SMEs in India, and as sir suggested that if we involve a professional for full time, the cost of employment goes higher. So can you suggest that if there is a SME, how can they trust a resolution professional in the later run when they can't trust those professionals beforehand? Because it's very rare, because as you know it's a very complex circuit in India. If you see, it's more of a family owned business, and they don't trust a resolution, they don't trust a new member coming into that, a resolution professional for that matter. So what are your suggestions on that?
So I'm not sure I understand the question. You're saying that the promoter doesn't trust the resolution professional?
No, not the yes, ma'am.
Yes,
Yeah,
Abhi.
you can
Yeah,
explain
yes,
it.
Abhi, go ahead, go ahead. So I think, Abhi, just for clarification, in case
Yes,
in
ma'am.
the pre-pack insolvency framework prescribed for MESMEs, the control is
Yes.
still with the corporate debtor. So I think this
Yes.
problem of trust does not happen, and the management is dislodged only in certain cases. So I think what you're asking is about a neutral party sort of driving the insolvency framework, if at all. How does corporate debtor trust them? Is that your question?
Exactly, ma'am. Exactly.
So I don't have a good answer to that. I'm sorry.
So let me just give a very a passing comment on that. See, Abhi, the trust will always be an issue between the corporate debtor and insolvency professional, because at the very premise is so opposite, right? One is trying to resolve the company, take over the management, not in the case of mesmes but generally, and there's a corporate debtor who wants to keep holding on to the information. So our center did a research and we found out that there is a lot of information withheld by the corporate debtors in case of insolvencies, and this was felt by most of the resolution professionals handling the cases. Now I think, yes, yes, sir.
No, go ahead. Go ahead. Go ahead.
No, so no, I just wanted to say that this is something which will not be easy to build in. And I think you made a very good point, sir, about debt counselors. So, probably it's the time to have a more, a different sort of intervention in an emerging economy in form of maybe debt counselor, especially for small companies, where do not see them as somebody who's antagonistic to their own interest, but rather they could seek their professional help to
Yeah.
redesign or restructure the debt. I think, yeah, yes, sir.
Yeah. To me, the distinction there is not between small business and large corporate. The distinction is between professionally run business and promoter run business, right? And I know in India you have a higher proportion, even in the large corporate sector, of kind of owner run businesses. But where you have professional management, they see the resolution professional, yes, not as their friend, but certainly as the vehicle through which they will engage with their creditors to restructure the business, right? And ultimately, as you know, in a large corporate restructuring, if you don't have support of a significant amount of your creditors, there's no point going forward, right? It's not going to work. And so they see the resolution professional as a facilitator. I think at the MSME end, yes, that trust, that greater personal trust is required, but that's why the resolution professional comes in, as I said, as you rightly pointed out, or as I mentioned earlier, as more of a debt counselor, as more of an ally of the debtor, but with an overarching obligation as an officer of the court, with a duty to behave ethically, not a duty to one particular creditor or a particular group of creditors, but a duty to the court.
So, any questions from the audience? Yes, Professor Relu, if you could speak into the mic, please. Yeah, you're not audible, Professor Relu. Yeah. Akriti, in the meantime, would you like to put your question?
Hello, am I audible, ma'am?
Yes, yes, you are.
Yeah. So my question to Mr. Mahesh is that we discussed that we have almost 6.3 crores of MSME in India, whereas we are following a procedure of corporate debtor in the place, and in the normal IBC procedure, that's creditor are the ones who are holding the management, and they take an active part in it. So my question is, do you think it's a good idea for a country as large as India to have an altogether different act, maybe different code for special circumstances like MSME, or is it a good idea to, maybe co-align the IBC with respect to MSME? I mean, do you think we can think of a altogether different regime for MSME?
I can't see a compelling reason to do that. I think building it within the existing IBC framework is probably the better approach. I mean, ultimately, it comes down, those questions come down to kind of complex legislative drafting questions. But I see one of the challenges that the IBC actually solved in India was this patchwork, right, of legislative approaches. You know, whether it was SICA combined with other legislation, and I think I am much more in favor of bringing it under one code. And I think the MSME insolvency elements will draw by inference or by actual application from other parts of the IBC, right? But with very tailored and specific, you know, so for example, commencement process, right? What you have to file to commence a proceeding. It would be framed the same way as the IBC commencement process, but with specific conditions for SMEs that maybe made it simpler, or cheaper, or faster.
Thank you, sir. That was very helpful. Thank you.
Yeah, and you know, even from the legal standpoint, the jurisprudence, there's a convergence in the way jurisprudence sort of evolves when you have it in within the same court. Professor Relio is back, and you can go ahead with your question, sir.
Yeah, thank you so much, Dr. Niti, and my apologies. It seemed that the technology wasn't working well in Singapore. So Mahesh, thank you so much for such a wonderful presentation. And it's a great pleasure to have the opportunity to know your views on this exciting topic. I would like to ask you two quick questions. The first one is about how to fund the procedure for SMEs without enough assets to even cover the expenses of the procedure. So in particular, I'm thinking about the remuneration of the IPs, even if they have a supervisory role, which is much more affordable, but still, I guess that's a challenge. In Singapore, as you know, we have adopted this simplified insolvency program, and the fees of the insolvency professionals involved is partially subsidized by the government. But realistically speaking, I don't know if that approach sustainable in the future, or if it's going to be sustainable and realistic in some emerging economies, for example. So I would like to know your views on how to fund the procedure for this type of SMEs. And secondly, it's about the extension of the discharge of debt. In SME with corporate form incorporated, could extend the discharge of debt to the shareholder managers, guaranteeing the company's debts. So in other words, if the company itself qualifies as an honest but unfortunate debtor, would you give the discharge of debt to the guarantors? That's why guarantees would disappear. And if so, do you think that banks may respond ex ante by requiring a security interest instead of a guarantor? And that's why SMEs without the ability to provide any type of collateral may face a problem in getting access to finance. So thank you so much.
Those are both very good questions. Let me tackle the second one first. I don't think that's the right answer. I think you can push the discharge down to those individual guarantors in their personal capacity if they are insolvent. But if they are solvent, I don't see a good policy reason for allowing them to be discharged of those guarantees, right? I think the fundamental principle still that shareholders are at the bottom of the pile, as it were, holds true in the context of guarantees as well, right? So I don't see a good policy reason for doing that, but I may be missing something. On the first question, I think this is an essential question in so many emerging markets, and by the way, not just in the context of SME restructurings, but also in the context of liquidations, right? No asset bankruptcies. I think that some sort of state support is probably required, and that requires, of course, that the state sees this as a pressing priority, right? In addition to obviously having the fiscal space to do it. But another consideration you could imagine is to construct a kind of ex-ante insurance fund, right? To deal with this, that is essentially a tax, for lack of a better word, on either on corporate insolvencies or on, you know, on banks if they are the primary creditors. I mean, you could construct a kind of shared pool concept like insurance that funds this type of thing. Some countries try to do that through a levy on assets sold, right? So any asset sold in any insolvency or any liquidation, a levy could come off the top of that, like a tax, that first and foremost goes to the state's coffers, right, before it even goes to secured creditors, that then funds these types of activities in the broader approach of wanting to fund the insolvency system writ large, and would also fund no asset bankruptcies, right? So I think that's one way to think about it. Another way is to look at the, you know, directly at the lenders and the RBI. I'm not advocating this specifically in the Indian context, but the RBI does have I think, a stronger relationship than many reserve banks with its key constituents. So you could imagine it implemented there. But I agree with you, solving that problem is a principal issue.
Thank you so much, Mahesh.
Any other questions from the audience? I have promised Mr. Mahesh that I will end the webinar at 6:30 because he has another commitment. So maybe we could take the last question. Yes, Om. Please feel free to speak.
Hi, good evening, Mahesh. How are you doing? Since we can see from the data that 97% of MSMEs in India are shaped their legal structure through sole proprietor or partnership firm, and insolvency of this MSMEs usually involve interplay of personal laws also. Uh, Recently, the Insolvency Law Committee has also proposed that instead of having a straight jacket formula for every individual that comes under MSME, why not create a separate mechanism where individuals who are having business, mainly MSMEs, could be covered under that portion? So, how do you think that interplay would be, and is that a good suggestion for MSME especially?
So covered under what portion? I didn't quite understand that.
Individuals having MSME ownerships. So, like you said, that individual MSMEs are structured in individuals or like sole proprietor or partnership firm. So they are covered separately in unlimited liability portion.
So if I can just sort of simplify his question from a policy perspective, I think maybe what he's asking is how formal should be insolvency regime for an informal sector be? I mean, put it very simplistically.
Yeah, I think that comes back to your first point, Niti. I don't know that you can solve the challenge of informality in this way, right? I would hate to say, well, you should just ignore the informal firms, because I understand that's a significant part of the population of firms, but I think that then you're talking about a much broader challenge, right? You really have to try and attack the challenge of informality, because I don't see how you know, insolvency will still at the end apply to a very tiny percentage of the total firms in India, right? And so to craft a solution that also responds to the informal firms seems to me maybe too much of an overreach.
Yep, thank you. Mr. Nagesh Prabhu, if I could just take your question as the last question. Any other questions, audience, please feel free to mail me directly. Yeah.
Thank you, madam. My question to Mr. Mahesh. Sir, Mahesh, sir, very good morning. Of course, I am in Texas right now. When our government has given an ordinance about this, I just wanted to compare the things, whatever available in US. I just found some interesting facts also. I just wanted to ask you certain things about those interesting facts also. Similar to our structure here, when our government has announced pre-packaged insolvency, like here also one pre-package is there for small companies. By name, 1 second, I'll tell you the name of the paycheck protection program liquidity facility to this small business purpose. Almost similar lines it is there. But how far this US government will be able to come to the rescue of this when compared to our Indian government? I saw that Indian government guidelines are very much useful for our MSME sector. Here, this protection, of course, I did not see further about this BCG report available here in the States. Still, I feel that similar type of program is also available here. I just want to compare those things and see that, and of course, I highly register because yesterday only I got the message from madam saying that this program is there like that. But still, I'm happy that our government has given a strong put to our MSM sector compared to these people here. Still, I just wanted to comment. I just wanted to share this news to you, sir.
Well, thank you for sharing that. I think that's a great way to end this discussion.
Thank you. Thank you. Thank you so much. And Mr. Mahesh, you're right on time now. It's gonna be 6:30 in another 40 seconds. So thank you so much. And again, on behalf of IACA family, GIP family, and everyone here in India, I would like to thank you. I think we all know your contribution to the development of insolvency regime in India. Even before coming of IBC, you've been very proactive, and your timely intervention, interjections, your advices has really helped the government shape up its insolvency laws. And I think this is something for which the country will be very, very obliged and grateful to you. Thank you so much, sir. And we hope to see you again. And thank you, Mr. Sagar, also for joining us. All our participants, our friend Professor Rello, and all the GIP students, thank you so much for joining. Thank you so much.
Thank you. Thank you. Bye-bye, everyone.
Thank you.
Thank you,
Thank you,
sir.
Niti madam.
Thank you, sir.
Thank you.